In the matter of Directorate of Revenue Intelligence versus Rajkumar Arora, Supreme Court allowed both appeals filed by appellants and held that both trial court and high court committed error in holding that offence under provisions of NDPS Act is not made out. Trial courts in both appeals could also not have discharged or deleted the charge under NDPS Act framed against accused person while disposing of application under section 216 of CRPC. This is something not permissible within our criminal procedure, and the High Court unfortunately failed to take notice of this aspect. On 27 September 2003, an officer of Department of Revenue Intelligence Headquarters received an information that several glass ampoules containing injectable preparation of buprenorphine were stored in an office premises in Jhandewala Extension Cycle Market, New Delhi. The further information was that injections had been illegally manufactured and cleared by MS Wind Drugs Limited, Bhiwani Road, Jeet, Haryana, and few injections, along with raw materials of buprenorphine, could also be found at the location. Two teams of DRI HQ officers were deputed, one team to undertake search of premises in Delhi and another who coordinated their action with Office of Central Excise Commissionerate Rohtak for purpose of search at premises of Wind Drugs Limited at Jeend, Haryana. On same day, 27 September 2003 at 8:15 p.m., DRI HQ officers visited premises in Delhi with a search authorization under Section 41 of NDPS Act along with two witnesses. It was stated that upon entering premises, Rajkumar Arora, who was proprietor of MS Kanishka Cargo Service, was present in office premises. DRI HQ officers recovered 25 corrugated cardboard cartons which contained small packets, each having 10 unlabeled glass ampoules with watercolored liquid, along with several sheets of printed labels which read as Buprenorphine Hydrochloride. They also recovered one labeled glass ampoule containing same colored liquid from table drawer of respondent. Upon preparing detailed inventory, it was stated that one labeled and 40,000 unlabeled glass ampoules containing buprenorphine hydrochloride, which is a substance listed in the schedule to NDPS Act, were recovered. Since respondent was unable to provide any permission or license for possession of recovered glass ampoules, they were seized under provisions of NDPS Act. Samples were drawn and test memo was prepared in presence of respondent and witnesses. On 27 September 2003, on same day, officers of CEC Rohtak are said to have seized 23,400 injections of buprenorphine along with 100 grams of buprenorphine in its powder form from MS Wind Drugs Limited at Jeend, Haryana as well. In response to summons issued, respondent appeared and said to have made voluntary statement in writing which mentioned that during course of business as customs clearing agent, he came in contact with Muhammad Shivar Khan, who handled custom clearance of drugs and medicines on behalf of Devang Bipin Parekh of MS Sarvodaya Enterprises, Mumbai. Statement further revealed that fact that respondents were collectively involved in illegal manufacture, storage, transport, sale, and purchase of buprenorphine hydrochloride along with one Naresh Mittal of Wind Drugs Limited. Supreme Court concluded that it cannot be said that the dealing in of buprenorphine hydrochloride would not amount to an offence under Section 8 of NDPS Act, owing to the fact that said psychotropic substance only finds mention under Schedule 2 NDPS Act and is not listed under Schedule 1 of NDPS rules. There exists nothing to indicate that Rules 53 and 64 of NDPS rules, respectively, are governing rules in respective chapters. More so, when language of other rules in Chapter 6 and 7 are clear about their application to substances mentioned under Schedule to the Act as well. All psychotropic substances mentioned under Schedule 2 Act have potential grave and harmful consequences to individual and society at large when abused. Some psychotropic substances mentioned under Schedule 2 NDPS Act are also mentioned under the D&C Act and rules framed thereunder. This is only because those substances, while capable of being abused for inherent properties, could also be used in field of medicine. However, the mere mention of certain psychotropic substances under D&C regime would not take them away from purview of NDPS Act if they are also mentioned in Schedule to NDPS Act. Court said that there arises no occasion for us to declare interpretation given to Section 8 of NDPS Act and relevant NDPS rules by decision in Sanjeev V. Deshpande as prospectively applicable. There exists no overwhelming reason for us to do so. On other hand, in order to meet ends of justice and with view to ensure that public interest is safeguarded and to give effect to salutary object behind enactment of NDPS Act, decision must necessarily be retrospectively applicable. Court in Sanjeev V. Deshpande perhaps did not think fit to confine or restrict its interpretation of Section 8 of NDPS Act to future cases only. This is evinced from fact that whilst overruling Rajesh Kumar Gupta case, it deliberately chose not to discuss doctrine of prospective overruling, let alone resort to it. This conspicuous silence in Sanjeev Deshpande as regards prospective or retrospective effect of overruling Rajesh Kumar Gupta case has to be borne in mind and given due deference. As natural corollary to aforesaid, Supreme Court said we see no reason why we should deviate from default rule of retrospectively and instead resort to doctrine of prospective overruling. Therefore, pending cases, if any, which were instituted before decision of court in Sanjeev V. Deshpande would also be governed by law as clarified by it. Furthermore, retrospective application of dictum in Sanjeev V. Deshpande would not give rise to implications as regards rights of accused persons under Article 21 of the Constitution. This is because while overruling decision in Rajesh Kumar Gupta case, decision in Sanjeev V. Deshpande case has only clarified law as it stood from its inception and given true effect to meaning assigned to relevant provisions of NDPS Act and rules thereunder by the lawmakers. The same cannot be construed as creating a new offence. Additionally, overruling of a decision cannot be equated to the enactment of ex post facto law, especially when interpretation given to the statute or the provision in overruling decision is not a novel and unreasonably expensive interpretation of provision in question such that it was completely unforeseeable. It cannot be argued reasonably that indiscriminate dealing in the substances which are only mentioned under the Schedule to NDPS Act and absent under Schedule 1 of NDPS rules was indubitably legal and allowed by the legislation prior to decision in Sanjeev V. Deshpande case. Therefore, there remains no doubt, Supreme Court said, in our minds that giving a retrospective effect to decision in Sanjeev V. Deshpande case would be necessary, considering the facts and circumstances in background of which we are called upon to adjudicate these matters. In view of law expounded by Supreme Court, since accused concerned in both appeals were not acquitted in respective trials, it was directed that they be tried by the concerned special judge NDPS in accordance with law. The trial courts were directed to proceed with the trial and conclude it expeditiously.